The first presentation I had was in Spanish with Estefan Encarnacion, who talked to us about estate planning. And the second part of our series was Suzanne Graves with long-term planning and probate. And today we are going to be interviewing Genoveva Meza Talbott, and she is also an attorney in estate planning and family law mediation. She has been practicing in Southern California since 2003. In 2018, she founded Meza Talbott Law and is in Claremont, California. She's also of counsel with law offices of Vera and Barbosa, and the founder of the Law Unbundled.com. She's a public speaker and also a board member of various recognized nonprofit organizations serving the community. She received her JD from the University of Southern California, her BA from the University of California, or UCLA. She better known.
UCLA, USC, yeah.
She is also fluent in Spanish and conversational French, and she lives in Claremont with her husband and 2 children. With that, I'm gonna let her tell us a little bit more about herself and present to us something that she would like to tell us about her estate planning. Go ahead.
Thank you, Lupe, for having me. And, you know, I'm so happy that we have this technology, especially right now during the pandemic when we all have our routines a little different. But they have this technology to educate people and take the opportunity to share information that normally we may have not done so freely or readily because, you know, we were always trying to do them in person and different, you know, have presentations at different locations, you know, and that's so much more difficult and complicated that many of us, I know myself, you know, always so busy with my practice and my family that, you know, sometimes I just wouldn't fit in the time to do something like this, even though there's so much information that a lot of us in different professions want to share with the community. So thank you for facilitating my ability and others to get the word out, educate by providing information about things that we can help people with. So like you said, so I practiced, I've been practicing for what, 16, 17 years, I don't know, time's flying. But I did family law and divorces for many years. And then in recent years, I added the estate planning because you know, I think it goes really well with my family law practice because it's dealing with families, you know, the things that are important to them. And for years, I would get requests from clients and colleagues and other, you know, professionals that I work with. If I knew somebody, especially if I knew estate planning attorneys that spoke Spanish, and really that was hard to find. And then generally, I just wanted to, anyway, you know, I became a lawyer to help people, to serve. And so any way that I can find that I can do that effectively, you know, provide good work, and then I do that. But it took me a while to get it going. And I'm so happy that this is something I can do for the community. And right now, during the pandemic, it's been especially busy for me because estate planning is something that a lot of people don't want to think about. They associate it with death and incapacity, which is what you should do because that's part of what you're planning for. But, you know, a lot of people don't want to think about it, right? They just want to go about our day. Nobody wants to really think about it, but it's planning, right? It's peace of mind. And so right now, unfortunately, because of what's been happening with the health crisis, people have no choice but to think about these things and to really think about the unexpected changes that could happen to their health and in their family structure. And really they think about protecting their families. And that's all estate planning is to me. It's and so I have a presentation that I wanted to share with those that are watching, and if you watch it later, that just gives a general overview, sort of foundational. If you know some of this information already, well, it's just gonna, you know, sort of summarize it for you. But there might be some things that you learn. And after I go through the presentation, we'll definitely have plenty of time to go over questions. So please put your questions in the comments and we will try to get through as much as we can after the presentation, okay? So let me, okay. Can you confirm, Lupe, that you see it?
Not yet.
Oh, here we go. There we go.
Okay.
Now you see it, right?
Yes.
Okay, great. All right. So that's me. Yeah, and so here's my information. We will provide it to you throughout the presentation at the end in case you have follow-up questions or would like a consultation. For family law, I do charge for a consultation but for estate planning, I do a 30-minute complimentary. Obviously, right now, all of my consultations are by phone or by video. I used to offer them before, but I also have the in-person option, and that right now is not something I do, but it's going to be similar to this. So if you're interested, you can get my information after the presentation or throughout. That's not a problem, okay? All right. So what is estate planning? And to me, it's just a tool, okay? It's a tool to leave a legacy. Because without, this is a tool that's been around forever. I mean, in the United States, this is how money has been passed on for generations. This and life insurance are two of the ways that people have been able to pass wealth, assets to families for generations. So it is definitely a tool that we all have to learn, just like we learn other tools to create wealth and things we do to buy houses and collect assets for our families. This is a tool, and you shouldn't ignore it, and you shouldn't not take advantage of it, right? Don't leave this tool for just certain people. It's for everybody to be able to use. So it's a tool to give what you have, whatever that is, to whom you want. So you get to decide the way you want it. Again, you decide how and when. So it gives you ultimate control over your assets and your legacy. And I think that that's one of the things that most people, when they hear that and they really understand the control aspect of it, they realize it's something I need to do now while I'm healthy, while I'm okay. Because when you don't plan, and we'll talk about that, you lose all control. Absolutely. And, most people during their lifetimes control every aspect of their lives, control their money. You don't just let anybody in your family go into your bank account and have debit cards and, use your checks and do what they want. Yet when you don't plan, essentially you're just allowing everybody who's left behind to try to do what they want and what they can do with your assets. So it's really a tool that you should utilize that really helps you control how things are going to be done when you're gone. Okay. I'm sure that the other presenters in the past weeks talked about it. To me, estate planning, people think of it, and I don't know exactly what people think about it, but I have an idea that people think it's for very wealthy people and it's only about planning for when you die. And those two things are wrong. The first thing is it's not just for wealthy people, right? It's for anybody that has assets. And assets, can be a house, it can be cars, it could be retirement, it could be bank accounts, it's personal property. All of that is your asset. So I always tell people everybody has an estate. And so estate planning is just planning for all those things that you have, right? But the other thing that it's not just for when you die. I think a proper sort of comprehensive estate planning should cover not just death, but also incapacity. Because statistically, right, many people have periods of time in their lifetime where they are incapacitated, either long before their death or sometimes very close to the time of their death. And so that's a very crucial element that has to be part of estate planning. Yes, I know some of us estate planning attorneys, some will just help you with a will, right? Dealing with the death part. But I really think that's a disservice to the community to tell them, oh yeah, if you just have a will, for example, that's it, you're done, your estate planning is done. I don't think that's the case, because really a good plan is gonna cover the incapacity, and it's gonna, which it says disability, there really should be incapacity and the death, because you wanna be able to, part of the planning that happens is to plan for yourself if you're, incapacitated, and for the family that you leave behind, your loved ones, whoever those may be. So incapacity planning. So the three documents that, or the three main things that when you think about incapacity planning are the Advanced Healthcare Directive. And that's basically like a power of attorney for health, right? And a lot of people learn the term power of attorney. What is it really? Well, it's a legal document. You know, yes, people can try to do it themselves, and there's different, you know, forms out there circulating, but the ones that attorneys draft are very thorough. Okay, so it's not just, you know, Genoveva, appoint this person to be my power of attorney for my health. It's not just a one-page document. What we try to do is really provide a lot of different, you know, scenarios in that document. So not only is it dealing with who has that authority to make decisions on your behalf if you're incapacitated, right? But also how you want other things to be done with respect to your health care, how the medicine, you know, and if should you pass, sort of what should happen. It's a very thorough document. It discusses a lot of different things that come up when you're incapacitated due to medical reasons and you're in the hospital. So that is a really, really important document, especially right now. Okay, I've read too many articles right now that the hospitals all across the nation are basically lamenting that if only people had this document in place right now with the pandemic, things would be much smoother and faster at the hospitals, because it is a document that is immediately effective when you're incapacitated, and there isn't, you know, a delay in getting the right person there, the right person that can make those decisions for you. So unfortunately, I think that's a big negative, that so many Americans don't have these documents ready, especially when there's so much illness right now. It's a super important document. So one, because it's practical, right? It helps the hospitals know, everybody knows, but I like to think about it as well when I talk to especially parents that have big families or kids, and it is a document that prevents a lot of heartache, emotional heartache for the families, right? Because, you know, it is a very stressful time when somebody you love is sick. And then there's a lot of people that love that person, and guess what? Everybody wants to have a say, everybody wants to have an opinion, and there's disagreement. I know it happened in my family, you know, years ago with my grandmother. It happens. So with this document, you are able to take that away to some extent by allowing your family to know. Everybody will know. It'll be clear what you thought would be best. And it really reduces the amount of stress in the families. That's one thing that is not often talked about, but it really helps with that, because that's one less thing for your family to be dealing with and stressing out about when tensions are high. Then kind of related to the Advanced Healthcare Directive, that power of attorney for health, is the HIPAA authorization. So HIPAA, many of you, if you work in healthcare or anything, or have gone to the doctor or anywhere, you sign this HIPAA authorization. So this document, you know, years ago, you know, I'm talking, you know, a couple decades ago, it was much easier to be able to talk to doctors and get information about your family members. It was much more loose, but not so much anymore. So when basically, it's a long name, but like the Privacy Act was passed, it got very strict because they had to protect people's you know, personal and sensitive information. So now, as many of you have encountered, you go to the hospital because your aunt is being treated, you can't just talk to the nurse. They won't talk to you. They won't show you test results. So the HIPAA authorization is sort of it goes hand in hand with the power of attorney, but that one doesn't give the people you list on that HIPAA, and you can list more than, you know, a handful of people there. That's just an authorization to allow those people to communicate with your medical providers and sort of have access to your medical information. It doesn't empower them to make decisions or anything. That's what the Advanced Healthcare Directive, but the HIPAA is also important if you want certain people, key people or people you trust or whatnot, to be able to have that access to your medical providers and nurses and things like that. So that's the first sort of the very sort of specific to the medical, right, issues of incapacity. The other document that I always tell people is very important is a power of attorney, just a general power of attorney for financial things. Because, and I believe that in your last presentation last week, you talked, the attorney was talking as well, how you were talking about how do you save houses that are going into foreclosure, right, after somebody has passed. Because what happens? Somebody becomes incapacitated, which is very, very common depending on their age and their health risks before they pass. And during that time that they're incapacitated, nobody, if they don't have a power of attorney, and especially if they're, you know, not married, nobody has access to their money and cannot manage all their financial affairs. And that's why it's so common that, you know, when somebody gets sick and they don't have anything in place, by the time they pass away, their houses might be in the foreclosure, bills haven't been paid. It's just a mess. Why? Because nobody is empowered. Just like I talked about the HIPAA, that it used to be much more flexible. I know for myself, because my husband opened our, he is the main sort of account holder of our cell phone bill and our cell phone account. When I call, if I want to make a change, I can't, right? They have to speak to my husband. He has to authorize because he's a main account holder. Well, that's just a cell phone, right? So imagine bank accounts and anything else more that is important to your sort of financial life. A power of attorney is the only one that would empower someone to have that ability to manage your finances, go to the bank, pay the medical bills, pay the house, be able to call the, some people say, well, you know, my partner, my whatever, they have access to my bank, they can just log and do that. That's fine, but that only gets you so far, right? That person can't really get on the phone and make any changes or do anything without your authorization. And if you're incapacitated, you know, it's done. So the power of attorney, usually people make that only effective once you're incapacitated. So you don't have to worry that if you give, you know, someone your power of attorney for the finances, they can just go ahead and do things while you're alive and healthy. No. It's, we can set it so that it's only effective if that person is technically declared incapacitated. And that kind of gives people a little bit of a peace if they worry. It should still be somebody that you trust, right? That is good with money, that is good with money because, and I mean that not that there's some financial whiz, but if you are incapacitated and this person loves you very much, not everybody handles death and illness the same. And I always tell people, don't always think about the person that it loves you the most, for example. That person might not be in a good shape to handle some of the things that have to come when you are incapacitated. So anyway, so that's, I think, equally important when one thinks about planning for incapacity is the power of attorney for the finances, okay? And I have living trust here because, you know what, if you do have a trust, and we'll talk about that, the trust also has language in there and directions and guidance for people should you become incapacitated. So it's not just a document, unlike a will, which we'll talk about. A will, it only becomes, a will has absolutely no power until you die. It's just a document that's waiting to be activated when you pass. But a living trust, that's what it's called, living, right? It's a living trust, is alive the moment it gets created and executed properly. It's a document that already can be utilized for certain things. And definitely you can use it to help guide the people that are, you know, your trustee and whoever you put in there to deal with certain things while you're incapacitated. Okay, but death planning. So now if we talk about death planning in particular, so that's the will versus the living trust. They both allow you to control your property while you're alive and well. And that's very important because, like I said, you don't lose control. Sometimes people get nervous, you know, they own their house. They don't want anything to take away any of their power with their house, right? For example, I don't want anything to sort of, it's my house. I get nervous, I protect it, you know. But you have to remember, the will, like I said, is just a document that doesn't really have much power at all. Actually, it has no power until you die, right? So really, it's not gonna do anything. While you're alive, nothing, it doesn't control anything, any of your assets, it doesn't do anything. And the living trust, even though it is different than the will, it is something that is has a power and authority now, to put it one way. You are the one that controls everything. So let me show you. So let's talk about living trust. So like I said, the will, in the will you'll put what you want to give to whom and who's going to do what, all the instructions, right, that happen when you are dead. Because I have to always tell people, think about it, in California, dead people can't own anything. So if you think about that, the moment that you die, you shouldn't own anything, which means if you made a list of everything that you own while you're alive, car, house, bank accounts, insurance, whatever it is you have, all of those assets should have an instruction of what happens the moment you die, so that when you die, nothing ends up in your name. Does that make sense? So a will is sort of, because the will doesn't have any power until you die, the will, all it's doing is saying, okay, now that you're dead and you can't own all these things, this will, you will take it to court, probate court, and they will use that will to basically make those transfers that you're saying were going to happen. But things can't just stay in your name, right? So I just wanted to point that out, because people sometimes don't understand why they can't just die and things just stay, like, you know, houses just stay in my grandmother's name and then we could just keep living there and doing stuff. No, as somebody that has passed away, you cannot own things anymore. Okay, so you need to do something. And if you don't plan, we'll talk about it, then the state of California will do it for you and you will have no control there. So a trust, the living trust, I like to think about it. You can see here the screen. You know, you are the trust maker. You are the person, and it could be, I mean, this is an example of a single person, but it could also be a married couple. But you know, you are the trust maker. You create this trust, and this is your trust here, and you put your property in it that you want protected. I always think of it, try to tell people, it's like you create a corporation, like your own little corporation, and you are the CEO, the CFO, that you control everything, and nobody else works there, manages it, or could do anything. It's your own little company that you created, right? And while you're alive, you can put things in it, you can take things out, you control it fully, right? And if you're doing it with your spouse, then both of you usually have the same equal ability to make changes. That's very important, to make changes. Just like with a will, you can always make changes while you're alive. You can, you know, revoke a will, make a new one, make changes. Living trust, the same. But the living trust is a little different because it's already an active document while you're alive, okay? So this is your trust. You're the trust maker, but you're also the trustee usually. You're also the person that manages everything. You created it, and you manage it. So what happens is when you pass away, usually, well, here, if I look here, the lifetime beneficiaries, a trust maker. So you set who is going to be benefiting from this, like, corporation. Let's put it this, not a corporation, so don't, you know, I'm just using it as an example. You know, these are the people that benefit, usually you, your spouse, your dependents, you know, everybody there usually benefits from this trust and the things that are in it. But then when you pass at death, it's your beneficiaries. It could be people, it could be charities, it could be a combination of things. So I really like to show this to people so they can see sort of how visually, you know, you create this thing, you fill it with things, you control it, and then you leave instructions for what happens when you pass. And the big difference that I think other presenters have brought up is that, unlike a will, like I said, a will, because it doesn't do anything until you pass away, unlike a will where when you pass away, you have to go to court to get the court to basically make all those transfers. If you have a living trust, you don't have to go to court, all right? This document is already sort of set up so that you're giving the document enough instructions, and you have the people already set up so that they can execute the wishes that you've laid out without having to go through probate. And I know people think about that. I don't want to go to probate. Well, this is, you need a living trust. That's the one way that you don't have to go to court necessarily. You don't have to make the trust sort of be effective when you pass away, and to start really making those changes of title and all those different things, okay? Now, I know that there was other presenters that talked about special needs more in detail, and I'm not going to go into it much, other than, you know, if you are a parent that has children with special needs, for example, you definitely need to consider a trust. They are a really great tool to protect your, you know, your special needs, you know, child or whatnot, their benefits that they receive. There's different types of trust, and obviously in a consultation with an attorney, we can go over sort of what applies to you, but there's ways for the trust to protect so that if you leave assets for them, they are not considered part of their assets to disqualify them from some of the benefits. So it's there's more to talk about in that. And I believe that the previous presenter last week talked about it. But yeah, this is something that if you are a parent that has kids with special needs and you're interested in a trust, this should definitely kind of convince you to look into the option, because it could be a very big benefit. Okay. And the last thing, and we're going to answer questions about all this, but the last thing I want to say, part of what I like about estate planning is that estate planning is also, it's not, you're not just money, right? So part of what estate planning does, it allows you to sort of what I call leave a legacy of values. Maybe you haven't thought about that, right? Maybe you have, but didn't know if that was even possible. And I always tell people, you're not just money, you're not just this bank account, you're not just this house, right? You have a lot more to you that you can pass to your children, to the people that you love. It's a public statement, not public in the way that, a will is public, right? Because it's a court procedure. Living trust is not public per se, but if you donate, to certain charities, or what charities you donate to, even if it's, you can decide how much, $1,000, more than that, that says a lot about you. And I feel like I always tell parents of young children or children that have children, it's a way for you to show them what you value, the things that you find important. And I think it's really great to be able to do that with your estate planning. You can pass down faith values. Like a lot of families really value education, higher education, college degrees. It's one way that you can, in your living trust, sort of set in your estate planning, sort of make it very clear that that's something that you want your children or your beneficiaries to do, and why. So anyway, I always like to say that, because it isn't just about the numbers, right? There's a lot more. Estate planning is just really passing down so much more. And I think it's important to think about it that way. Okay, so just to the benefits, just to summarize. So one, the avoids of family conflict. I cannot tell you, and I'm sure if you know anybody like you, Lupe, if you know anybody that has had family members die without a will or without an estate plan in place, many families have a hard time recovering from the drama, the stress, financial or otherwise, that the whole process of dealing with a death, unexpected death of somebody. So, your wishes are in writing. You minimize as best you can, the stress that your family members and your loved ones have to deal with when they're making decisions. Basically, you take away a lot of the decisions that they would have to do by you just leaving it in writing what you would like. And then those are going to be followed. So I think that one's huge. And again, just talk to people that have gone through something like this, and their families have just been torn apart dealing with this. Probate, we talked about probate, but the one thing I didn't mention, so if you die without any planning, like I said, just you say, you know what, I hear that, the house isn't going to get lost, my kids are going to get it anyway. I don't have to plan, it'll be fine. Well, California does have laws and rules on what happens if you don't have any estate planning. There is a law. So, if you're married, I'm just going to say generally, if you're married, it depends on some things you own are community property, some things you own are not considered community property. But let me just speak generally, okay? So you need to talk to an attorney specifically to know how your case works. But generally, if you've been married for a very long time, and let's assume all your assets are community property, as in 50-50, right, in California, if you pass, yeah, your community property passes to your spouse. This is if you're married, right? And if you have kids, let's say if you're not married though, you don't have a spouse, then that's where things start getting a little bit different in the division. So just generally in intestacy laws is what they call it. When you die without a will, it goes to your spouse, and the next in line is kids. And then if you don't have kids, it's your parents. And then if parents, it's siblings. And so once people think about that, they don't know what the situation is going to look like when they pass. They might not want one of their sisters to end up with everything. They might not want, their mother. We all have very distinct desires of how we want things done. But if you don't write them down, it's just you're not going to have control over that, okay? But the other thing about avoiding probate is the fees. So not only do you lose control of who gets what, but there is a cost, okay? that you will not get around. If in California, I believe now the minimum is 166,000 is the minimum. So if you pass away and you have less than that, you don't have to go to probate technically, usually. But I will say this, in California, it's very easy. I know it doesn't sound like it, but it is easy to have more than that in assets. Because why? If you own a house, forget it. You know, likelihood of you already meeting that or being above 166,000 is easy. Add a car, add a retirement, a bank account, all these things. Because why? When California is calculating the size of your estate, they don't discount debt. So people think, well, I might own a house that's 500,000, but I owe like 450. Well, they wouldn't really take that into account to really value your estate. So it's sort of the gross estate. So you will have to, your family will pay technically, because what happens is the money might come out of your estate, but it's less money that is going to be distributed to your family. So, and it's, like I said, it's between 3 to 7% list. Generally, again, it's more specific than that. And the law, attorneys don't decide how much to charge really for this. The law sets out how much of a percentage we get from every estate. But I always tell people, if you, just for example, if you have about $500,000 in assets, which I know, like I said, is not that hard if you own a house and have like a little pension, retirement, this, you know, that would be about, I think, 13,000 or so. That would just come out of your estate. They'd just be subtracted and paid to the attorney like myself. That would be then doing what you were supposed to be doing, right? Those transfers and all those things. Because you didn't do it, then attorneys have to do it. And we were going to get paid a percentage. So if you want to really save your family from spending, having to reduce that estate that you're going to inherit for them, that's definitely one thing you want to do. And then probate is public too, like I said. So a lot of people don't really want their business out there. And if you have to go through probate, it will be. And again, the controlled disposition, that's what I was talking about. If California, if you don't decide, they'll decide for you. And the last thing here that I didn't mention as we were going through, but part of what I do, and most estate planners should do, is when we're doing either, if it's a will-based plan, we do will-based plans that don't include a living trust. Some people, it is a better fit for them. So in a consultation, we sort of discuss that. But regardless of whether it's a will-based plan or the living trust with a pour-over will, because there's always a will regardless of whether you have a living trust or not. If you are a parent with minor kids, you need to have guardianship instructions. And some people just have like a one-page thing that says, so-and-so is going to be the guardian if something happens to me. And they don't think much about it. They're like, well, I'm married, so my husband, you know, is going to, or right, automatically the father or mother of your kids, if you pass away, gets custody of your kids. Yes, but what's happening, like I was reading articles that, you know, with this pandemic, you know, there's, for example, the two parents are in the medical field. And I read terribly sad articles about these parents that are, you know, both doctors or nurses, and they have little kids, and they realize there's a great chance, a big chance that both you and I can get sick and possibly, hopefully not, and may die, right? And so they, you know, these people in the medical field were dealing with their guardianship, and they were putting all kinds of people on that list because so many people around them were getting sick in like states like New York, for example. They had, you know, the list was like 5 people down the line, right? So that's the current situation. But even if you take away this pandemic, I always tell parents, don't assume you don't need guardianship because you're married and your spouse. I always tell people, I know you don't want to hear this, but do you guys ever travel together? Do you go on date nights and drive together, right? Things happen. And, you know, the best way to have that peace of mind, if you have small children, is to have a plan in place. And I personally don't just do a one-pager that says, these are the people and this is the order that I would want, you know, my kids to. No, I make what I call a child guardian plan, which is a little bit more robust. I include not only that, but I like to separate who, because you can, as a parent, decide who would raise them and who would manage their money. It could be 2 separate people. It could be the same person. You can also, you know, I include things like when you go travel or when you go just on a date night or whatnot, whoever is your caretaker, there should be documents that give those people the authority to take them to the hospital if necessary. If you're a parent, you really need to talk to an attorney about what options you have to leave a plan for your kids. And it's super important. I think most people neglect that, and just saying, oh, well, I told my sister that, it's her, or, or they were baptized and they're, I'm talking about a legal document, so that if something happens, that person has this document ready and it's smooth for your kids, right? Think about your kids. It's smooth for them, the transition. So that's something that, because I have young children, I think about that all the time. Okay, so anyways, here's my contact information. I'm sure Lupe will give it again at the end and have it in the video, so that you can contact me. So yeah, that's what I have. So I know I've been seeing questions pop up, and I'll let you, Lupe, I'll take the sharing off, and I'll let you sort of monitor that and let me know what I can answer. Okay.
Sure. Thanks a lot. It's been great. All of that information is great. I actually have experienced a little bit of everything, not personally, but that I've seen. Either clients of mine or friends of mine that unfortunately have had to go through things like that. I do have some questions. I want to go and I want to answer. Let me see some of the questions that I had already and see if I can incorporate some of the questions that some of the audience has.
Okay.
So, so one of the questions that I had planned to ask you had to do with someone who has a business, and there is a question on that. One of the questions says, well, it's a little bit of both. It's two questions in one, but okay. It says, we already have a trust. Should all property, houses, cars, bank accounts be in the name of the trust rather than our names? And the second question to that is, what about my company, sole proprietor? I have no plan of who to leave that to, I have no plan of who to leave that to, and nothing's in writing.
Yeah, this is, there are a lot of business owners now, you're right. I feel that in the last 10 years, I seem to definitely know more people that have taken that entrepreneurial route and have businesses. And, for the person that asked the question, they already have a living trust. Great. Because, but if you're, okay, so I'm going to talk generally, and because really it can be very detailed, the advice given. And remember, everything that I've said today is general information, right? This is not legal advice. You cannot rely on it. Really, it's a public forum, okay? In order to really give you legal advice, you have to be in a consultation with me, and that's private, confidential, and that is what really creates that attorney-client relationship. So everything I say today, what I've said even in the presentation, is just general information and not to be considered legal advice, okay? So I always want to reiterate that so that people realize that, this is a starting point to be educated, but that to really look into what applies to your case or not, you really have to take that next step. But, businesses and planning for that is crucial, especially if you are a sole proprietor. If you are the only person that owns that business. Why? Because if you pass away, the business essentially dies. If you're a sole proprietor, all the assets that business has, I don't know, depending on what the business is, in it, for example, if there's equipment, different things that go with that business, those are considered personal property because you're the only owner. So, essentially you pass away, the business, dies with you. So if you don't want that to happen, and you need to have something planned and in writing. There's different ways to do it. One of the most common ways is for people to have like buy-sell agreements. And that is, for example, if you have a business, even though the business doesn't have to be small to be a sole proprietor, right? It could be a big business, but there's still just one owner, you. You have this business, but there's, a key employee that, that you could do the work, could keep this business going after you pass away, for example. So what you would do is, and this, again, this is just very general, but, there would be a buy-sell agreement with that employee. Usually it's funded with a life insurance. So for example, there would, there's an agreement that the business is worth X amount of dollars. That agreement between that employee and you would mean that that employee, there would be a life insurance bought, okay, on you. worth that amount that you agreed the business is worth. I'm just going to say 100,000. So if you both agree that business is worth 100,000, there would be a life insurance bought on your life for 100,000, and the person that's paying it is that employee. They're paying that life insurance, right? And also they're the beneficiary. So that part of this agreement, if you were to pass, the life insurance for that predetermined amount would be paid to them, and that's how they basically buy the business. Does that make sense? So that is a most common thing. There's, if you have corporations, and it's a little bit more complicated, but if you are a sole proprietor, you really do need to talk to an attorney about what are the options for really planning out what would happen with your business. Okay.
Okay, great. And then you did touch upon this a little bit earlier when you mentioned about the 3 to 7% in regards to probate. But the question is it 3 to 7% plus the lawyer fees for representing you?
No. So those are the fees that are paid to the attorney. So normally most attorneys that handle probate like this, they do it, it's almost like a contingency, right? We don't actually charge you while we're doing all your probate because we get paid from the estate directly at the end. The courts can pay attorneys sooner, a portion of it, like advance it, right? If there's a lot of work, for example, or the estate is very large, and so there's money to basically not make the attorney work for whatever many months without any pay, but it isn't, traditionally, it's not like you pay the attorney plus then at the end, they also get a chunk, right? So that's not okay, and a probate court would not like that, that the attorney is basically double dipping and getting paid from the people as well as from the estate.
Okay. All right. And then, you mentioned about the children earlier in regards to having a guardianship, and, that is assuming that you have your, that there's a married couple. How about if the parents are divorced? How can they protect their children? Or should they each want to have include them somehow in the living trust, or how can they do that?
The guardianship, I mean, again, yeah, I think if you're unmarried, it's even more important because, and even if you were never married and you just, have a child with someone in a relationship, because I have a handful of those clients, for example, just legally by default, if you were to pass away, the other biological parent sort of by default gets custody of the child, right? So, okay, that's fine. But believe it or not, so you can't say, so if you are divorced from your husband, for example, and, you can't do a guardianship and say, well, if I die, the kids go to my cousin and they don't go to my husband. That probably wouldn't happen. Okay, the court would say, no, dad gets first dibs, right? There are exceptions, and I do tell people this. There are exceptions, okay, in certain situations. And that's it, even if the father, I'm just using this example as the father is the one that's surviving. Even if the father was not married and it was just from a relationship. If that father didn't have custody for very valid reasons, okay? If a court did not give them custody for very valid reasons, legitimate sort of concerns about how they would raise their children. So if you are, there is a way, it would be very helpful for you to have a guardianship document that, I do this as well. And with my clients, I ask them, is there anybody that you absolutely would not want to raise your kids? Because what happens is, and then there's documents that you can prepare so that if you were to pass away and the court says automatically, oh yeah, father, in this example, father just gets the kids, and you would just be horrified to know that that was going to happen. Then at least, there's family members, the family members that have your estate plan and have all these documents that have documentation that they can then go to court and present and basically fight for, getting custody of your kids based on what you left as your desires, right? So it's almost like your last attempt as a parent to try to advocate for your kids. So I hope that answers the question, but, I feel like, if you are, and then the other thing too is even if you're married, I tell people I have both parties do their guardianship, and they don't have to put each other, right? Because that's the default. It's more about a couple layers after, because this guardianship, if you're the one that passes first, then it's what your husband is going to put that's going to matter, right? And because if you pass away, he's the one that's in this example anyway, he's the one that's his guardianship document's the only one that's going to be used if it's ever used. So those are important conversations I have my parents do. They have to talk and sort of agree, because they have different ideas of who would be better for this, who should manage the money versus who to raise them, right? And so those are kind of the few very important conversations that have to happen when it comes to guardianship, so that everything matches as best as possible. And we kind of talk about all the various scenarios and try to cover all of that.
Great, great. So I have some scenarios for you, and these are related to things that I've seen throughout my time as a real estate agent. So how about if there's a homeowner who his wife has died, and he has a will drawn, and he leaves his primary residence to his grandchildren, and his daughter is the executor. And a few years later, he remarries and decides to have a new will drawn, and he's leaving the primary residence to his new wife, but he dies, and then the new wife tries to sell the property, but she's unable to because there seems to be a cloud on title. Mm-hmm. And then they tell her that it's because he never revoked the first will.
Yeah. So this is part of, and I hate to say it, as an attorney, I cannot recommend that people go and do their own wills and their legal documents, right? As an attorney, I just can't, because I've seen too many problems. And this is one of the things that happens. A will in California is not necessarily complicated, but there's different requirements, okay? And so sometimes people, like in this hypothetical that you're talking about, things go wrong. So what should have happened is that when you create a new will for someone, it specifically has to revoke. That's what attorneys do. We check to make sure to revoke any prior wills, right? So sometimes if people are doing it themselves online or forms, it won't have that language. And that's what could be very common, or they're not properly executed. So it could also be that the second one, maybe say it revoked it, but then it wasn't properly executed, right? You need 2 witnesses, there's different things. So, or maybe the second one, when it was done, the person was sick, right? Mentally, it wasn't all 100%. That's another thing that would make that will not completely valid. Or there is evidence or suggestion that this new wife sort of manipulated this person and made them do that. So, but any of those reasons are good enough for there to be that, like you said, that cloud on title. But what does that mean? That means probate that we talked about, right? It means that you got to go through essentially litigation to sort this all out and try to figure out which one was the most recent will. It has to be proven which one was the most recent, and make sure that all those other requirements are met. So yet again, this is the thing. These are legal documents. So, they have to be done properly, right? Because you're essentially, it's like trying to do your own, medical or dental work and then just kind of try to figure it out yourself. You're going to miss things. So this is what happens. I guarantee you, if you go and if I do a will, and if the person says, I think I have a will, I don't know, I'm not going to just risk it and not put, I revoke any prior, So anyway, that's a common thing because of the way people handle these very important legal documents themselves many times. So I think that's one of my biggest recommendations is don't think that it's because it looks like a simple document. If it's a legal document, it has to be done right.
Right. And then, I was also going to go back to the living trust. When someone does have the living trust, and it has to do with the previous question also, do they need to put, all their assets into the living trust?
No, they don't. And a lot of times people don't put all their assets, they put in the big things. I always think about the big things, the big ticket items. Essentially the things that, kind of like we talked about, the things that were you to pass would have to be, dealt with because there has to be a title changed to this. So the only, so when we talk about setting up your estate plan, that's part of what we go through. We go through all the assets and we kind of figure out, you know, if it's beneficial for you to put it in the trust or not. A lot of people, you know, like their regular checking accounts and things, they don't put that in the trust. They just want to have a little bit more easy. But if you have a sizable account with, you know, kind of a big chunk of money in it, you might want to put that in the trust, right? Just like your house, usually people don't put their cars in trust. Those are the things we talk about, right? But it isn't a blanket yes, all or no. It depends on your particular case and what things you own, and that's part of what we discuss when we're setting up your plan.
I see. Okay, great. Okay, all right. And my other scenario that I had for you was, let's say there's a couple that buys their dream home, and then, you know, but for whatever reason, only one of them is able to be in the loan, and therefore only one of them is showing up on title as the owner. And then the one that's showing up on title passes away, and then the wife, you know, let's say assuming that it's the husband, the wife, or the spouse that survived the owner, now learns that they're not the legal owner of the property. What would they need to do to be able to protect that asset if that happens?
Yeah, this comes up just generally because I remember I did divorces for many years. So there's a lot of that happens for qualifying for better interest rates, all this stuff. But I think that to answer your question, the important thing is to remember that California is a community property state, right? So, and what that means, and this is a little more family law than estate planning, but that means that, you know, when couples do that, for example, and they buy things, and, you know, some things are in one spouse's name, the other, it doesn't matter for California purposes. Generally, anything that is bought during the marriage with marriage money and paid down with marriage money is marriage asset, regardless of the title. So if we start with that answer, then you could see something like a hypothetical like this, where this couple bought, and let's assume it's clearly a marital asset. She's entitled to, you know, because she's a co-owner, right? So in a case like that, there's a solution, but unfortunately, here we go again with the probate, right? So it's not like she loses her right, but she does have to, you know, you file a spousal property petition is usually the way you can just do it. And it's a little simpler than a full probate, because why? With that petition, if you're just able to prove that it's a marital asset and it's just a technicality of the title, then the court can just approve it and then change title. Because again, in California, you know, by the fact that you were married, you have that legal ownership to the community property. So it isn't, it isn't a problem that can't be solved, but, you know, it will require, you know, having to file in the probate court, and hopefully it doesn't have to be a huge probate issue. It's just a small sort of transactional thing, because it's common. People do this. It happens in divorces all the time. And, you know, so.
In that case, let's say, do they always have to go to through probate, even if it's something smaller, or is there any way that they could just file something with the county recorder's office?
If once one passes, the one spouse passed away? Well, no, I mean, the spousal property petition isn't, it's a pretty simple process. Okay. But, you know, county recorder can't change title of something with someone that already died. So again, this is what the probate court is for, but it's definitely not the probate that we've been talking about. It's just a petition. And a lot of times there isn't even like a court date. The judge just approves it if there's evidence enough that this is what happened. It's not that we don't own it together because of community property. It's just the title issue.
Great. Okay. So how about when mom and dad want to leave their primary residence or some sort of investment property, or even, I don't know, maybe even other stuff, assets that they might have that are valuable. But let's say in this case, it's a home, it's a real estate property, and they're considering different ways to be able to deed it to the kids. They might consider, maybe doing a transfer on death deed. Is that something that you would advise for them to do, or are there any other options that they can do?
So the other thing that people sometimes do is they just deed their things to their kids now. And, you know, I had a colleague, not a lawyer, that mentioned that casually to me, and I said, oh, no, 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 you don't want to do that. And the reason I said is because that means, and that child or that son, I think they're already over age, but still they own it, right? Which you're saying, yeah, that's what I want. I just, you know, I don't want there to be an issue that even when I die, I said, yeah, but guess what happens? That means that that house now is subject to, you know, if he gets sued, if he gets in a car accident and they sue him, guess what? That's an asset of his that can, right, be tapped into. Debt, creditors. Okay, so I started having this conversation. She realized, oh no, that seems risky. I said, yes, it is, right? Because now, what if they remarry? If they get married, guess what happens, right? They can do things, and this is not a family law presentation, but they can do things that then make that house or that new spouse sort of be able to tap into that house. And the mom goes, oh wait, that is not my intention. That's not why I was trying to do this. I said, well, there's other options, right? You mentioned the transfer on death. That is something that I think in 2016 is when that was approved. And it was, they call it like the poor man's live trust. And it's, and they say that because it was just trying to give people another option. And essentially this is a document. It's like it's a deed, right? So it'll be recorded where when you pass, it gets deeded to that person. And there are benefits to it for sure. And it's fast, right? It's easy. It doesn't cost a lot of money. But you know, for me, I think that it's almost too simple, right? So if it's a single person, it might even be an option because you're single. And so there's really none of that community property thing we were talking about. Because if you're not single, I really don't recommend it, because if you do a transfer on death to your kid, right, one kid, and you die, but community property, so that property then goes to your spouse. So that, you know, so there, right there, it already didn't do what you were trying to do. So that means your spouse has to then have an equal or identical one. So there's just, I always say that it's almost too simple. Okay, it's almost too simple. And what if you have a transfer on death for that property for a child, and you do it and you forget about it, you know, and then that child happens to pass before you, they predecease you. What happens there, right? Now you pass away and the person you said was going to get it is not around, and things happen. People don't expect that, but things happen. So you got to deal with that probate, you know? So I feel like there are situations where it might work perfectly, but I feel like the more assets there are, if it's investment properties, by the way, like apartment building, things like that, you can't do it. So it would have to be a single residence. You should be a single person to really don't get away from all those complications of the community property. Yeah, I mean, the Medi-Cal reimbursement, it's something you should talk to an attorney about, and we would be able to say, no, you know what, this might be good for you for this particular property. But, you know, I'm not saying it's not good for everybody, but I really think people need to explore, because a lot of times part of what attorneys do is try to figure out, what are you trying to really accomplish here? Like with the example I said of the mom that just deeded her, you know, 22-year-old son the house now. It was what I told her and what she tried to do to accomplish her goals, they weren't matching. So that's part of our job, to figure out, so what do you really want to accomplish? And then let's figure out how to better do that.
Right. It's more like it's the individual need of whatever, you know, it's not going to be the same thing for every person, right?
Yeah.
Everyone has different needs and goals.
Yeah.
So, okay. So then my last question is, you know, with everything that's going on right now with, you know, the current pandemic and, you know, people who are, you know, afraid that, you know, they might pass because of it, or they could get sick because of it. What are your thoughts about how people can protect their assets and their family during this current time and, you know, uncertain time?
Yeah, I mean, I think that sadly what's happening has, you know, pushed us to think about death and incapacity and all these things, but you need to take action. And I know a lot of us estate planning attorneys are trying to be flexible on, for me, like I said, I'm doing the free consultations by phone, or because you need to be educated. Don't be passive right now. Don't ignore what's happening around us. Okay. You need to, yes, a comprehensive kind of full estate plan will cover everything, right? But a lot of people, first of all, are intimidated. They think, oh, that's going to take forever. Oh, it's going to be very intrusive, or it's going to be thousands and thousands of dollars. You're making assumptions, a lot of assumptions. And I say, take the first step, book a consultation, find out really what is the process. Some attorneys have different process. I pride myself in having a very smooth, quick, efficient process. So I always tell people within a month, you can have all of this done. A lot of times we go faster than that, and the price is not as expensive as people think. All attorneys charge differently, and you'll have to find out and make your comparison. I'm not the cheapest one, I always say, but I also am not competing to be the cheapest one, right? Because I provide a lot of value to my clients. So you need to take that step, because I've talked about a lot of the things you can do right now, and you should do something, right? Something. Don't just leave it to, your family members to deal with. Don't just leave it to the state of California to deal with. You have so much control right now, but you do have to think about it as an investment, and really be willing to look into the options, and don't make assumptions. Okay. Presentations like these are great, but it's all general. It still takes for you to actually talk to an attorney. I can't recommend that you go do it online, because like we talked, this is not a cookie cutter, everything map is the same, one size fits all. The online and videos like these are great for general information, but you need to take that step and talk to somebody that can really give you those personalized options.
Great. That all of the information has been really great, very helpful. We are already, towards, the end of our presentation here. And before we end, though, I would like for you to give us again your contact information, and, so that we can go ahead and finish. There are some questions coming up.
Yeah.
But maybe, I don't know how you are with time, or if maybe we could respond to the audience.
Yeah, let me look here. I'm putting in the chat my information. Okay. And then okay, so there's my website, my phone number, and an email, so you can send me your questions. Unfortunately, I have another presentation I have to do soon, so otherwise we could keep going answering questions. But and I did want to mention as well that I do have a very easy way to subscribe. On my website, I have a lot of free resources. Okay, so definitely go to my website, especially about estate planning. I have a family law blog as well, but estate planning, I have hundreds of pages of free resources and booklets you can download. So go there, and but of course, if you want to set up a consultation to talk to me, go ahead. I also have a newsletter that I send out once a month, and occasional sort of free booklets I email. And I have a very easy way, by the way, a lot of you I know are not email. You can text the word MT Law, okay, to the number 33777, and that subscribes you, okay, to my email list. So there's definitely a lot of ways that you can get a hold of me to get information. But I also, like I said, just go to my website and you'll find booklets and all that. And but of course, if you want to follow up from today, feel free to reach out to me.
Great, thank you so much. Thanks for your time, and we'll go ahead. Hopefully we'll get to do another presentation in the future. And then also for the audience that we have one more presentation as part of the series coming next Friday. That's going to be with Kathy Bates. We're going to be talking about seniors, downsizing versus, whether they should be aging at home. So feel free, everyone, to register and log on next week as well. Same time, Friday at 11 a.m. Okay.
Thanks so
Thank
much,
you,
Lupe, for
everyone.
having me. And I'm glad to know that people learned today and enjoyed the presentation. Have